Welcome to Advocating for Dads with Jana Jones.
Hello and welcome to Advocating for Dads with experienced family law attorney Jana K. Jones. Jana has been providing father-focused legal services since 2009 and is passionate about fair custody arrangements in North Carolina. My name is Kevin Rosenquist. I am your host, and today's episode is Coping with Conflict, Strategies for High Conflict Divorces. Jana, great to see you again.
Hey, Kevin, great to see you as well.
All right, so we're going to get a little heavy here. So how do high conflict divorces differ from the more amicable separations in terms of legal challenges as well as obviously emotional challenges?
Yes, I'd say the biggest difference is the communication between the parties and motivations. So when you're dealing with high conflict cases, usually there's little or very contentious communication between the parties.
Right.
And the motivations for why they are asking for certain schedules to be put in place with children or certain assets or liabilities to be handled in certain ways, it's going to be a lot more contentious and high conflict.
Yeah. I mean, how do you manage that when they're high conflict? Do you just have to be steady Eddie and not like get too involved, or does it make your job harder?
Well, no, I believe that it's really important in a consultation to set the correct tone and talk about the type of attorney you are and the approach that you take to certain things, as well as to talk about what it is overall that you're looking to achieve and what type of results are realistic. So whether it's high conflict or relatively amicable, the laws of North Carolina don't really change.
Right.
And so what you can expect to get in settlement as it relates to the assets and liabilities or custody is going to be largely determined on what the facts and circumstances are at the time that the case is getting started. And that is whether it's high conflict or relatively amicable.
Do you find that ones that are high conflict, it's harder for people to get what they want out of it?
Not necessarily if you've got attorneys involved. Now, obviously, if you're trying to go this route on your own, then yeah, it's going to be darn near impossible to work with somebody if there's a lot of conflict. But the goal when you're hiring an attorney is to get that neutral third party who can talk to you about what you're wanting to do, can advocate for what you want, but also can let you know what the law is and what's realistic when it comes to expectations. And so as long as there's not high conflict between you and your attorney, you guys should be good, even if there's high conflict between you and the opposing party.
Yeah, that's a different kind of conflict right there. If you're having a conflict with your attorney, obviously emotions can make us all a little crazy at times or act, out of our norm. How do you kind of help your clients, keep their cool, or maybe just try to separate the emotion from the actual procedures that are happening?
Well, I try to remind folks that this, while it is probably one of the most difficult things that you're going through right now, will not last forever. Right. Eventually, you're going to get orders. This is going to be over. You're going to move on, hopefully find a new relationship, enjoy the peace that comes with co-parenting your child with this person after the conflict has been resolved, hopefully. I mean, the courts can't necessarily make the relationship better, but they can at least give you an order so everybody knows what the rules of the road are. But this is not going to last forever. I think it's important to remember that. And I always try to communicate that to my clients, so they recognize that this is a period of time. This is going to be something difficult to go through, but you will go through it. You will get to the other side, and life will get better.
I've not seen a ton of divorces in my days. I'm lucky in that respect. My parents still together, but I've seen some rough ones at the same time. Do you find that sometimes people almost don't want to give in because they don't want to give that ex-partner anything that they don't have to?
Yeah, absolutely. Especially in high conflict cases.
Yeah. How does that get managed? It's a tricky spot.
It is, and it's understandable. But
Sure.
Again, my job as your attorney is to advocate for what you want. But again, always be realistic and honest with you about likelihoods and expectations surrounding the facts and circumstances of your case. And so to assume that the other party will get absolutely nothing and you're going to get everything is unrealistic. And that's something that I'm going to be very straightforward with in a consultation and moving forward with representation. So generally speaking, my clients understand that because from the get-go, as much as I'm able to forecast and talk about likelihoods, I'm going to do so. And so there's generally not so much of that with the cases that I have.
That's good. That's good for you. I'm happy to hear that. What are some of the most common triggers of conflict during a divorce, and how do you think they can be managed?
So usually one of the biggest triggers is one of the parties getting in a new relationship.
Sure.
That tends to blow things up and it can't be avoided. Again, you're going to get past this. You're going to move on. Maybe you'll get in a new relationship at some point. And so that tends to be a really big problem and a big hurdle to overcome. But I always tell my clients this is to be expected. Your relationship is ending, it's over, and it wouldn't be realistic to expect that your partner will not move on, nor is it realistic to expect you won't either. So you've got to come to terms with that reality.
Yeah, that's a tough one. That was a issue for people in high school, right? I mean, that's it's always an issue when you see your ex with somebody else. Like being, when it's a marriage and when there's kids involved, that just makes it times a million.
Exactly. Yeah, it's a tough pill to swallow, but it's the reality. Life does go on.
Right. That's true. What effective communication strategies can help reduce the tension between divorcing parties?
So I would say ideally reduce things to writing. Email is the ideal way to communicate with one another. They make good exhibits as opposed to text messages, which if you're unable to get those into a format that the court can accept, can sometimes not work out as exhibits or not work out as well as exhibits. So I would say that use email as your primary form of communication. Obviously, if there's an emergency that pops up, maybe you guys have children and you communicate something specific to the other side, then you're going to need to be able to talk to each other on the phone on occasion. But
Right.
The vast majority of communication between spouses, especially when they're high conflict, should likely go through email. And it gives you a chance to think through what you're saying, think about the fact that this could be used as an exhibit, and kind of type in and write accordingly. And cooler heads tend to prevail if you are forced to put it in writing as opposed to just jumping on the phone and rattling off however you're feeling in the moment.
I've asked you before if you kind of have to coach your clients a little bit. Do you have to coach them at all on, hey, don't use that kind of language in the texts and the emails and stuff? Maybe just try to be a little more almost like, for lack of a better term, professional about stuff.
Absolutely. Yeah. And I think it can be helpful to take a step back, maybe type up the email exactly how you're feeling, just don't hit send. Then maybe go somewhere. Yeah, just think on it. Go get a coffee, go get a glass of wine, go get whatever you need to just take a moment to breathe, and then maybe edit the email based on what you're actually trying to communicate as opposed to just your emotions before hitting send.
One of the interesting things about parenting in general is just trying to, have your own life, but also keep your child as the focus and all that. And I can imagine that it's even tougher to keep that in mind when you're going through a divorce, especially if it's a contentious divorce and all of that. Do you find that there's a lot of dads in particular have a hard time, I don't know, like focusing on the child and not, and what's best for the children, and not sort of that battle that they might be having with their ex?
You would think so, but not really.
Okay.
Maybe I've just been fortunate with the clients that I've had. I've had some phenomenal fathers as clients over my 15 years, and they truly have just wanted time with their kids. Obviously that varies. Some wanted every other weekend, some wanted primary custody, and some wanted something in between, but they just wanted time with their children. They wanted to make an impact. They wanted to make sure that their children knew that they were loved and that they wanted them. So I haven't really had too much of that, thankfully.
That's great. I probably watched too many movies, but that's good. That's good to hear. What legal strategies should individuals consider when navigating a high conflict divorce?
So I think that talking to an attorney is extremely important. You're going to first want to get a consultation, understand your rights and responsibilities, understand the perspective of the attorney that you're considering hiring and how they tend to go at certain cases, their communication style, et cetera, and make sure it's congruent with what you're looking to do and what you're looking to have happen. So I think that's always going to be the most important and first step is that consultation.
In North Carolina, if both parents want primary custody and they're both perfectly capable of having primary custody and the court feels the same way, does it pretty much automatically go to a 50-50 co-parenting at that point?
I wouldn't say it's automatic. Everything is contingent on facts and circumstances.
Sure.
I mean, a joint custody arrangement is an ideal schedule, and I think it's the one that is typically the default schedule that you're starting from, particularly in Mecklenburg County, North Carolina. But there could be facts and circumstances that lead the court to believe that a different custody arrangement is going to be what's in the best interest of the child or children. So it really just depends depends on your facts and circumstances.
Case by case basis.
Absolutely. Yep.
Can you talk a little bit about mediation or any collaborative divorce approaches that can be beneficial, particularly in high conflict situations?
Yes, I think mediation is especially beneficial for folks, both when it comes to dividing up assets and liabilities, as well as talking about custody and child support issues. In North Carolina, and specifically Mecklenburg County, the mediators that we have are great. They are going to really try to help the parties come to an agreement, because we all know as attorneys how long, contentious, and expensive litigation can be. And if you're, going from start to finish on all of the issues, equitable distribution, alimony, custody, child support, those cases can easily take 1 to 3 years to get fully resolved and cost people thousands and thousands of dollars. And so if you can go through a mediation, full day mediation, and try to hash out all those issues, and you're able to settle those matters, that is the ideal way to go.
Can you explain a little bit about how the mediation process works?
Sure. So when you have a mediation, the mediator is a neutral third party who is trying to facilitate an agreement between two parties. And so what typically happens, both sides are represented, is that the mediator will get everybody together at the beginning, introduce him or herself, talk about their role, talk about any housekeeping items, and then they typically put us in separate rooms. So my client and I will be in one room, the opposing party and their attorney will be in another room, and that mediator will bounce back and forth between the rooms trying to facilitate an agreement. They tend to spend a lot of time with the first side because they're trying to get an understanding of the case, the issues of the case, and get a kind of a big picture idea of what we're trying to resolve and what the major issues are. And then once they've determined that, then they go to the other person and their attorney, kind of talk through the perspective from the first party, and then get the new person's perspective and try to see, is there any common ground? And then we just build from there.
Most of us anyway remember our parents fighting, whether it was in the next room, in front of us, whatever, most people do. How can parents kind of shield their children from conflict during and after the divorce process?
Yeah, so just keep the kids out of it. Try not to have conversations that are going to be contentious around the children. Try to have those conversations offline, separate and apart from where the children may be able to hear it. Maybe have those conversations in the evening once the children have already gone to bed, in the morning before the kids get up. And then again, going back to emailing being the primary form of communication, utilize that. Or maybe some co-parenting apps to try to communicate whatever the issues are. But ideally, just keep it away from the kids, because it's never going to be helpful to see them fighting.
I'm not going to hold you to this number, but in your experience, what percentage of cases are more high stress, high conflict?
I'd say in my practice, it's probably about 50-50.
Really?
Yeah. And it can change, right? You may have a situation where a party comes in, they become a client, they think, hey, this is going to be pretty simple. I just want this, they want that, easy peasy. And then we get into it, not so much.
Not so much.
Yeah. And then you may have a couple or a person who comes in, they feel like there's so much animosity and angst between them and the other party, but their estate or what they want with the kids, pretty simple, pretty straightforward. They're kind of on the same page. They're just not really good communicators, which is why their relationship is ending. It's not nearly as bad as they thought it was going to be. So, I know it's very lawyerly to say, but it really does depend on the facts and circumstances of every case.
Yeah, it just sort of depends on the person. Even if there is a more amicable divorce, if people are, they're really focused on what's best for the kids, do you still recommend any sort of mediation, or is it not really necessary at that point?
Yeah, so I think it really depends on whether or not you guys can come to an agreement on what you're going to do. If you can come to an agreement on what you want to do with assets, liabilities, custody, and child support without getting attorneys or the courts involved, bravo, good for you. Save money.
Save the money, yeah.
But if you can't, then the next step I would say would be mediation, to see if you can work those issues out with a neutral third party. And then obviously if that breaks down or is not successful, then litigation is going to be your last resort.
So if people are really truly amicable, and I know that probably doesn't happen all that often, where it's like truly, yes, we can completely come to an agreement, they can really go through the whole process without any mediation, without attorneys or anything like that?
Yeah, the state of North Carolina does not require you get mediators or attorneys involved. You can handle your divorce technically on your own. I don't ever recommend people do that without at least getting a consultation, because you don't know what your rights and responsibilities are, or what you may be waiving or giving up. And so even if it's amicable, you need to make an informed decision about what you're going to be doing. But outside of that, no, the court does not require that people have attorneys in order to get divorced.
What advice do you have for individuals who may fear that their divorce will continue to be contentious long after the legal proceedings are over?
So therapy is going to be important in that situation. The courts are very limited in what they can do. They can talk about assets and liabilities and how they're going to get split. They can talk about what the custodial arrangement is going to be and child support. But I've used this line many times over my 15 years. You are never going to litigate your ex into being a better human being. That is not something the court has the power to do. No judge, no attorney can fix that. And so, and neither can you, right? And you can never really change another person. You can only change yourself. And so the only thing you can do is change how you react and how you kind of ingest what they are doing. And I think therapy plays a vital role in that.
If a divorce is if people are deciding to get divorced and all of a sudden they start to realize, hey, this is going to be pretty contentious, how important is it to get to you quickly?
Very, very important. Again, you need to know your rights and responsibilities. You want to be well informed. And there are certain things that if you don't kind of strike while the iron is hot, become less and less likely to be successful in court. So you definitely want to get advice as soon as possible.
Well, that's, as always, great advice from you, and we appreciate it. Well, thank you very much for joining us on Advocating for Dads with experienced family law attorney Jana K. Jones. To connect with Jana, head to lawofficeofjkj.com and be sure to like and subscribe to our channel and leave us a review. Jana, always great to hear all the advice you have. Thanks for being here.
Thanks again.
Thanks for watching. If you like this video, don't forget to hit that like button and subscribe to our channel for more amazing videos like this one.